and welcome to Lex Novus. What happens when a Malaysian public authority makes a demand from a private entity for customer personal data? Must the private entity comply? What is the extent of data that can be demanded? Is a demand even legal? These were the questions that arose in 2019 when Genting Malaysia sought to judicially review the decision of the Department of Personal Data Protection.
Yeah.
In November 2018, the Inland Revenue Department wrote to Genting requesting personal data of the company's customers who were members of its Genting Rewards loyalty program, spanning the years 2016 to 2017. The loyalty program is a typical rewards-based program based on purchases made by the customer. The IRD justified its request by stating it would help expand the tax base and enhance tax collection efforts, asserting its authority under Section 81 of the Income Tax Act and specific provisions of the Personal Data Protection Act, PDPA. Following further communication, the IRD expanded its request beyond the loyalty program and included an extensive scope of personal information including addresses, total winnings and losses, total funds brought in and taken out of the casino, and more. The time frame was also expanded by an additional year. Genting, however, pushed back firmly, arguing that the IRD's demands were not only excessive but also illegal. It highlighted several key contentions, including that the requested data was outside the scope of what could be legitimately accessed under the Income Tax Act. It also pointed out that Section 81 of the Income Tax Act pertains only to tax-related information, not to the personal data of customers gathered through their loyalty program. Further, Genting retained an obligation to protect personal data under the PDPA, which specifically restricts disclosure unless necessary for crime prevention or investigation. They argued that the IRD's request did not meet these criteria and instead amounted to a prohibited fishing expedition. Genting also raised concerns about compliance with international data protection laws, such as the EU's GDPR and Singapore's PDPA, given that their customer base is global. On the other side, the IRD claimed the authority to request the data under Sections 39 and 81 of the PDPA and Income Tax Act respectively, suggesting that these statutes authorize them to access necessary information for tax purposes. The IRD portrayed their request as a crucial part of efforts to prevent tax evasion and to ensure proper tax compliance among high-value transactions and customers at the resort. To support its position, the IRD forwarded a letter it had received from the Department of Personal Data Protection, or the DPDP, which stated that the IRD did in fact have the authority to make such a request. Genting then wrote to the DPDP contesting this claim and received a reply from the Deputy Commissioner of the department. It stated that not only could the IRD make such a request, but that Genting was authorized under the PDPA to disclose such information to the IRD. Considering the implications of disclosure, Genting refused to accept the DPDP's position and requested a meeting with the Deputy Commissioner. No such meeting occurred, and Genting then promptly filed for a judicial review of the decision made by the DPDP. To analyze the key aspects of this case, we will aim to answer three main questions. First, can a public authority make a demand for personal data from a private entity in the course of carrying out its function? Second, what is the role of the DPDP in such a scenario? And last, based on this case, what is the scope of the right to privacy in Malaysia? Looking at the first question, the IRD's demand for personal data is hinged on its authority under Section 81 of the Income Tax Act. Sections 80 and 81 of the Income Tax Act provide for wide-ranging powers to conduct audits of a general nature. In their eyes, this authority was bolstered by Section 39 of the PDPA, which allows the data user, which is Genting in this case, to disclose personal data for purposes other than initially collected in limited circumstances including 1. For the prevention or detection of a crime, 2. Investigations, and 3. where it is required or authorized under any law. The IRD had admitted that the purpose of collection was to expand its tax base, increase tax collections, and reduce tax evasion. The court, in reaching its findings on this argument, first established that there is a constitutionally guaranteed right to privacy in Malaysia pursuant to Article 5 of the Federal Constitution. Referring to a string of cases including Sivaras Arazia, Muhammad Ghazali, and To Si Wei, it concluded that since the right to privacy is protected by the Constitution, any statute must be construed harmoniously with it. This is based on the presumption that Parliament does not intend its acts to violate the Constitution. This finding is critical as all other findings by the court in this case flow from this one determination. Turning its attention to the PDPA first, the court found that the 7 principles of the PDPA relating to the obligations of the data user are cast in mandatory terms by use of the word shall. Therefore, the disclosure principle under Section 8 of the Act is mandatory. How then is Section 39 to be dealt with? This is a section that exempts the disclosure principles in limited circumstances. The court first highlighted the juxtaposed use of the word may in that section as opposed to the word shall, found in all the sections relating to principles in the Act. It therefore concluded that Section 39 was meant to be permissive and not mandatory in nature. Interestingly, the court then went on to draw on the test of necessity from the UK and Europe. This test stipulates that where an infringement to the right of privacy is to be made, the party requesting the data must prove its necessity. This test, the court highlighted, is a strict test, and showing a real risk of a potential event is insufficient to satisfy the test. The IRD in this case clearly failed the test of necessity in preventing or detecting a crime or for investigation as its avowed purpose with merely to increase tax collection and reducing tax evasion. Importantly, in analyzing this principle, the court adopted the perspective that the argument of potential relevance, such as the broad reasons provided by the IRD, is insufficient to satisfy the test. Instead, there must be a specific instance prompting the request. In the absence of a specific reason to invoke the request, the court considered the IRD's request to be a fishing expedition, which was wholly contrary to the intention of the PDPA. In doing so, the court spent time expounding 2 doctrines of statute interpretation. First is the principle of genralia specialibus non-derogant, which stipulates that where there are 2 conflicting provisions of statute, and one is general in nature while the other is specific, interpretation will be in favor of the specific provision. Application of this principle had the effect of finding Section 81 of the Income Tax Act to be general in nature and the provisions of the PDPA, which are specific and constitutionally based, to prevail. The second doctrine is that an Act of Parliament shall not be used as an engine of fraud. On this point, the court drew significant guidance from the UK's Information Commissioner's Office guidelines and the UK's Data Protection Act, on which Malaysia's PDPA is based. The position there which was adopted is that without reference to a specific crime, use of a wide statutory provision to obtain personal data of an unspecific nature would constitute a fishing expedition and be a circumvention of a constitutional right. Further on the applicability of Section 39, the court agreed with Genting that the IRD was not a part of the federal or state government and thus was not exempt from the provisions of the PDPA. In fact, the IRD was clearly overstepping its bounds as it was an agency tasked with the collection of taxes and not an agency tasked with prevention, investigation, or detection of criminal activities. Moreover, in this situation, the court further queried whether the IRD could perform its statutory functions without such disclosure and concluded that it indeed could. In the Genting case, the conclusion in no uncertain terms was that the IRD had no authority to make a demand for personal data in the circumstances. However, returning to the first question posed of whether a public authority can make a demand for personal data from a private entity in the course of carrying out its function, we can garner certain important inferences. 1. The value of personal data held by a data user is significant and is guarded by the Constitution. Consent granted by a data subject will not, on its own, overcome obligations of the PDPA's disclosure principle. 2. If an authority's request for data is based in statutory authority and is precise in nature and meaning that it overcomes the necessity test, it may be entitled to such a request for information. 3. If there is an express provision of statute that excludes the PDPA's applicability, such a provision may apply. The court in the Genting case recognized such provisions and referenced the example of Section 76 of the Credit Reporting Agencies Act 2010. However, a consideration may be that as the right to privacy is recognized as constitutional in nature, there may be an avenue to argue against the constitutionality of any such provision. 4. As the court recognized the status of the IRD as a corporate entity, if this same demand for personal data were to be made directly from a federal or state entity, the Genting case may be distinguished. It will not, however, distract from the fact that the private entity is still accountable as a data user under the provisions of the PDPA, as there is no waiver of such accountability simply because the recipient of the data is not covered by the PDPA. This conflict will need to be reconciled by a court interpretation. We move now to the second question in regards to the role of the DPDP in the scenario of a request being made by a public authority for personal data. The handling of the entire situation by the DPDP in the Genting case left a lot to be desired. In her judgment, the judge made particular reference to actions amounting to a dereliction of duties on one hand and a presumption of authority on another. To determine the true role of the commissioner of the DPDP, the court referenced the Hansard and found that its role was firstly in favor of the public. 3 key points that were highlighted were that the DPDP serves as a body to protect the unlawful use of personal data, ensure compliance with the PDPA, to uphold the rights of citizens, and enforcement to prevent misuse of personal data. Against this backdrop, the court could not accept the argument of the DPDP that it could not be expected to investigate the motive of every single request from a statutory or regulatory body. The court instead found that this argument was in direct conflict with the function of the DPDP, and by raising this argument, it showed that the DPDP was willing to freely give away personal data without consideration, even if a request was unreasonable. The court also highlighted the DPDP's purported assurance through written communication that there will be no prosecution under the PDPA should Genting provide the requested information to the IRD. This, the court held, was presumptuous as prosecution under the PDPA is not within the power of the DPDP and lies instead with the public prosecutor. The so-called guarantee also did not account for a potential complaint by a data subject under Section 93 of the Act, which provides an avenue for a data subject not satisfied with the decision of the DPDP in refusing to investigate a matter to appeal to an appeals tribunal. The guarantee therefore had no legal basis and could not realistically be relied upon by Genting. It is therefore abundantly clear that the role of the DPDP in situations of a request for data by a public authority is not as a rubber stamp. Instead, it should, first and foremost, act to preserve the fundamental right to privacy provided for under the PDPA. This brings us to the third question on how the Genting case has affected the notion of the right to privacy in Malaysia. The judge took a decisive stand that there is a recognized constitutional right to privacy in Malaysia and supported this perspective by reference to 3 key cases. The first is the often quoted case of Sivarasa, which is not a privacy-related case. It dealt with the right of an individual who was a parliamentary member to stand for election in the Bar Council. The focus of Article 5 there was on personal liberty as opposed to privacy. The next case is the 2015 Court of Appeal case of Muhammad Ghazali. This case was a challenge to a state legislature enactment that was argued to be in conflict with constitutional provisions, including Article 5. The element of privacy here was in the context of an individual's right to dress as a different gender. While the Court of Appeal drew parallels with the Indian Constitution, It is important to note that the case of Gisele was taken to the federal court and the decisions of the Court of Appeal and High Court were overruled. This may have made the judge's reliance on the Court of Appeal decision in the Genting case questionable. The final case relied upon is the High Court case of To Si Wei. This case was in respect of a private hospital CEO who was dismissed based on emails which he claimed had been obtained unlawfully from his personal email account. The cause of action in this case was against two individuals for infringement of privacy and breach of confidence. The judge there explored whether the tort of privacy is an actionable civil right in Malaysia. While the judge acknowledged that the tort of privacy is a relatively new development in Malaysia and is still in a state of flux, he recognized its importance in the age of technology. This analysis, however, stopped short of a direct finding regarding such a tort, as there was no evidence of hacking into the email account and an admission that there was a right to bring up the emails to the trustees of the board. In comparison to these authorities, the Genting case, in drawing a comparison between the PDPA and the Income Tax Act, is able to draw a strong argument to establish a constitutional right to privacy. It is important to distinguish, however, that the Genting case is a judicial review application and relates more to obligations under the PDPA rather than development of the tort of privacy. Instead, the Genting case sets a good foundation to build upon the constitutional right to privacy aspect. That's all from us in this episode of Lex Novus. See you next time.
Yeah.